Ronald Payne, how are you?
Okay, can you take off your mask for a few seconds so that way I can verify you're Ron Payne? Okay, thank you.
She didn't see you before.
Yeah,
saw
I
you
didn't see you before.
Well, my hair's longer than it's been since before high school. I had a haircut this year. But it's still me.
No, she didn't see you even.
Just that I didn't see you.
Oh,
Yeah.
just being respectful. In public, I try to wear a mask.
Okay, so who hired you?
I was contacted in March of 2019 by Andover Companies and State Auto Insurance Company jointly, and asked to represent the association in defense of the lawsuit that had been tendered to them.
Do you want to go with that chain of questions on your end, or like me, go ahead
You can go in with your...
when I feel it?
Yeah.
Because you're a prisoner for me.
Yeah. Because he's got some questions too. Just that right now he's typing.
So after that, what happened when they contacted you? Isn't it part of your process to talk with your client right away and get their approval to represent them?
It works different ways, but I guess in this case it's not confidential. I was given contact information for the association, and actually what I often do is I reach out to the other side of the case, which is what I did here. I reached out to Mr. Alan Alhamzi because he was the plaintiff in the case, to let him know that we were coming in to represent the association.
Well, you called me on March 14th, and I documented that with the association records. But you never mentioned you're calling me as an adversary. We were talking as me, a board member, and I informed you of that. But
that's not true.
I'm saying it's not true either, but I don't want to spend time on things that we disagree on. I just want to ask. So don't you find it weird that you talk to the adversary, but you don't talk to your client? Well, isn't your client supposed to tell you?
I'm not here for a deposition, Alan, and I'm not going to be questioned by you like this. I have confidential information that I can't discuss with you because you are a conflicted board member. I mean, you are the plaintiff in a case, and you can't very well question me about a case where you're the plaintiff.
Well, this is an internal board business. Whatever the board.
Right, and under the laws of Illinois, a person who is a plaintiff in a case on a board must recuse themselves from all decision-making in relation to a case.
Can you cite the law?
That's the law in Illinois under the Not-for-Profit Corporation Act, as well as the Corporation
Which
Act.
section?
Section.
I didn't come to say section in it, but Alan should very well know.
Well, I mean, you're an attorney, you need to know more than Alan.
You know, if you cite the law, you have to specify,
you have to specify.
the section.
It's an ethical responsibility of all board members. They owe a duty to the board.
So it's not the law, just that.
So it's not the law?
It's all right, it's okay. He feels hostile, we don't
Okay.
welcome. It's just like he wants to come in and explain himself.
Okay, that's fine.
And he doesn't want questions from me. Maybe if you want to ask him questions, that's okay.
No, there's certain information I can share, and there's certain information I can't share because you're in the room.
What if two board members were the plaintiff and one was the defendant?
Then the board members would have to recuse themselves from decisions involving the board.
Does the Act specify anywhere that you can recuse yourself from your duties and powers? Because it's a power and duty to be a board member to do that.
Correct, and it's in a power and duty of a board member to act in the best interest of the corporation, and if the board member is a plaintiff in the corporation, they have to recuse themselves from decision-making in relation to...
Or a defendant, maybe, if that's true, which is not. But
actually, no, the defendants, individual defendants, as well as the corporation have a common interest.
In the derivative claims, or?
No. A corporation, if there's a lawsuit, you're speaking in the abstract, if there's a lawsuit against an association or against a corporation, the officers of that corporation, unless there's some conflict between them and the association, have a common defense.
No, but for example...
So defendants do not have to recuse themselves. Individual defendants don't have to recuse themselves from a suit where they're co-defendants. But a plaintiff suing an association can't very well act on behalf of the association in relation to the same lawsuit.
So he cannot attend board meetings?
No, that's not what I said. I said
He cannot attend board meetings where they discuss...
they can attend board meetings, and then they have to recuse themselves during the portion of the board meetings where the lawsuit is being discussed.
Well, you said this before, but you never sent me any specific law that says this. If you sent it, I would comply. If there's a law, like specific law, you know, in court, there's no like general talk. When you cite something, you cite a specific section and paragraph where it says something. Then you base your argument on it. You're an attorney from 2006, I think. Isn't that right?
I have been attorney since 2006, yes.
But the other part is not right.
What?
The other part about citing a specific part of the law?
Sometimes you go into court citing the specific parts of the law. Sometimes you don't. Sometimes you do research and prepare for something.
To cite?
Yes.
It's okay. So just in the case of our lawsuit, it had derivative counts against the defendants for which the association would gain money, right? Would gain damages.
Realistically, that's not going to be what happens because none of your derivative claims that you put in your lawsuit would be something that would get the association money.
Why not?
Well, you should know that all those claims were dismissed, and they were properly dismissed by the judge.
You moved to dismiss them, representing the association. Isn't that correct?
I have been retained to defend the association in the lawsuit that you have.
Yes. So this applies to the counts where the association is defendant. But you moved to dismiss the counts where the association is plaintiff.
Correct, because you didn't have standing to bring those lawsuits.
If you're uncomfortable with the mask, we're okay. If you have to take it off since you're far away, it's okay. Say that again, please.
I said because you did not have standing to bring that.
Yeah, that's your argument in the motion to dismiss. But I'm talking in the abstract of the complaint. When there is a complaint, whether I have standing or not, whether I hire an attorney or not, whatever the mechanics of it, when there is a complaint where the complaint itself, if successful, the claim itself is successful, the association doesn't pay anything, rather gets paid. And you moved to dismiss those counts. Isn't that correct? The derivative counts.
Correct. The association is not going to end up paying itself in the lawsuit. The insurance company doesn't insure the association.
But she's not a defendant in those counts. The defendants are the individual board members.
No, that's not correct. In your complaint,
I drafted my complaint.
Yes, you had a very messy complaint, and often within the complaint, you had some derivative claims. You had some claims against the association in those derivative claims, and I charted all of them out. You had claims against the association.
We can discuss one specific one. There's one about the roof for $127,000. The association is not named a defendant in that count. It's against Michael Mento, Lisa Mianovich, Three Brothers Trust and Round Trust. The plaintiffs are me and the association derivatively. You recall that count, right?
Yeah. Count 4 and 5, you filed about the roof. Correct. You filed them, Ellen and Noir, and the Arthur Condominium Association against Mr. Mento, Ms. Miatovich, and the Rand Trust and Three Brothers Trust. The same with count 5, according to this public document.
Okay, so can you apply what you said to this particular count? Let's say the association, instead of moving to dismiss it, which is what you did, on your own. We as a board, we didn't tell you to do that. Let's say the association kept that count and asked to join it through the attorney who appears on behalf of the association, be it you or anybody else. Then it wouldn't be derivative anymore. It would be something that the association, if successful will get paid for, right?
Well, according to the court order, that's not the only reason why that count was dismissed, but you have a fundamental misunderstanding of what would happen as a result of the lawsuit.
But you can answer my question you're evading. I want to ask you, if
I'm
you
not
as an
evading,
attorney-
I can only speak about stuff that's not confidential.
Let's say if we say you're our attorney now, and we want you to bring these counts against the defendants, will you do that?
Well, no, the scope of my retention, the scope of my agreement is to defend the association lawsuit. It's not, the insurance company doesn't retain us to be an all-around 24/7, whatever the association.
Yes, but those counts, the association is not a defendant. You still worked out of your scope because you say to defend, but the association, as you just admitted, is not a defendant in those counts.
If the association would like to authorize a lawsuit against Mr. Mento and Ms. Tovich and those two trusts in relation to the roof and masonry contract, they'd be able to hire an attorney, hire me if they like, and pay fees to do that separately. But this was part of the 27-count complaint that went over 390 paragraphs, and so as part of that, I am to defend the association.
Yes, to defend.
And that's what I'm doing.
But you're still evading my question. In that count, the association is not a defendant to be defended in the first place. It's a plaintiff, a derivative plaintiff. Isn't that correct?
Purportedly, but there was a reason why it was dismissed, is because it was improper.
But who moved to dismiss it?
I in the association, moved to dismiss it.
Who gave you instruction on moving to dismiss it? Who told you this has to be done as a defense strategy?
That is confidential information.
But the association is your client. It's confidential to the association.
You are the plaintiff, and I can't have a conversation with you because of that.
Do you want to whisper it to
You
Shelley?
want to whisper it to me?
She's a defendant. She's not a plaintiff.
Right. I'm not going to sit here and whisper to show
You can write it on a piece of paper, show it to her. I'll turn my head around.
Okay.
Is it somebody that instructed you to do this, or you did it on your own?
As a lawyer, you're not always instructed to do everything you do in a defense. You work with your client in the defense. And at the time, I was reporting to the custodian.
On
And as part of the
March?
strategy was to move to dismiss your complaint because most of the counts were not legally valid.
In March, you appeared on your own on March 20th. There was no order for the custodian. Actually, up until this point, there's no order for the custodian to manage the defense. To coordinate and give you documents, that's what you moved the court to enter, but not to manage your defense. I'm talking about specifically the order that was entered on April 24th, 2019. Isn't that correct?
I'm sorry, I don't understand what your question is.
You said you reported to the custodian, right?
Correct.
From what date did you start reporting to the custodian?
I started reporting to the custodian after the court ordered it.
What date was that? Are you getting late? As you look for the time, what do you think of the custodian in general? How did he do his tasks?
I think that hiring a custodian to represent the association was a massive mistake on your part. I think that you should never recommended that you hire Phoenix.
I followed the court orders, which the individual defendant moved the court to order those orders. I didn't.
I don't
order for that.
I know what.
But it's okay. Let's say I hired him. Let's assume that I am the one who moved the court for that. You reported to him, and you said you reported to him. At least you worked with him. What do you think was the level of him performing his duties, the ones entered by court, specifically about the money of the association?
My personal opinion is that the custodian should have never been hired. I think that it's a financial disaster for this association.
But the custodian was hired for a $300 a month fee to do the financials, not to do everything else that you moved the court to change. You moved the court, and the court entered those orders to change his tax.
Actually, that's not true. The only thing I did was ask the court to report.
But still, you're evading my question. I'm asking.
I'm answering your question, Alan, and I'm sitting here. You're recording me, and I know that, and you can't just browbeat me. If you want answers,
I just want facts.
Your questions are unfounded. When I came into the case, I called you to say that I was going to be representing the association.
And I told you no.
And you told no. What you told me was, I'll think about giving you permission to represent the association. I have never had a plaintiff authorize me to represent a defendant ever before in my life. That's not the way it works. In a lawsuit, the plaintiff doesn't give permission to the attorneys to represent the defendant. So when that was the case, and I found out, no, I'm giving you a full answer. If you want to keep interrupting me, you're not going to get the full answer. So I found out, I realized that it was going to be a tenuous situation because I couldn't very well report to you who's the plaintiff in the case. So I went to the court and I asked the court what to do. The court suggested that I have a report to the custodian. Then I moved.
The court suggested that?
Yes.
When? What time?
The first time I talked to the court, there was a hearing in.
I was there in all court, the hearings.
No, you weren't.
So you talked to the judge alone without me?
No, there was a hearing you didn't show up for.
Which date was that?
There was a hearing in late March, and there was some kind of a motion that was brought.
Some kind of a motion? General answers.
Well, there's been about 25 motions in this case. So there was a motion that was brought to continue a deposition when I was just entering the case, and I informed the court that I was coming in and that, I asked for direction, and they suggested that I go to the custodian as a contact.
So they told you that by phone or?
No, I was in court with the judge, with other defendants there, and I believe you were on the phone, because you weren't there.
There has been no phone appearances.
It wasn't with Judge Taylor, it was with the presiding judge, and it was very early in the case.
Yeah, we filed a motion for an emergency protective order regarding a deposition.
You're right.
That was even before, you say you had authorization from the custodian, so you filed a motion to protect me from discovering information related to the association with one of the deposees or that person.
That's not what I did.
Okay, yesterday the custodian sent you a petition. How much money is he asking the court for?
Actually, I didn't realize the custodian sent the petition. It was actually dated in April, so I didn't realize that their notice of their petition was related to a petition from 5 months ago. But they're asking the court for $76,000.
Yes. So I wasn't served with it either up until yesterday. Not only you.
Well, I look back, and you were served with it back in April. I just didn't realize that their notice was referring to the April.
It wasn't filed to the docket. I checked the docket. There's nothing filed on April 7th.
Yes, the custodian, I think I have it in here, is asking for $76,000 from the association.
What do you think of that?
I think that it was a mistake to ever hire the custodian.
So if we ask you to dispute that, are you going to do it?
I think Mr. Mento has been...
You said defend us.
Mr. Kigallan has been working strenuously to go against the custodian.
No, Kigallan represents the individual defendants. He is asking money from the association.
Yes.
So if the association asks you to dispute that amount, are you going to do it?
I would be happy to, point it out, but I haven't reviewed their bills. I do think they
point out
what?
Point out what you said. Happy to point out, but you didn't say point out.
I'd be happy to point out that they overcharged.
Are you going to dispute it in court if we tell you to do that?
If you tell me to do that, well, you can't tell me to do anything because I don't
board
represent
tells
you.
The board.
Yeah. If the board, I would certainly file my objections to the amount that they're charging, because I do think that it was a mistake ever to get.
What are those charges for? They are mostly attorney fees, right?
Yeah. Before I ever entered the case, they had entered a order. I believe it was in.
My question is...
I was pretty shocked at the amount that they were asking for, but before I ever entered the case, first the custodian was granted, Then the custodian came in on a motion to have their attorney's fees approved. I had nothing to do with that. That was before.
But you talked to the custodian in March before you appeared. When you called me, you said you talked to the custodian.
Yeah, in February 2019 is when the custodian came in and...
Yes, that's the order I drafted with the specific $300 a month
Motion of
only.
our plaintiff for making of the association. Yeah, on March 14th, this was before I got in the case, the custodian moved for approval of engagement of counsel so they could retain Williams, Bax, and Saltzman at the expense of the Bell and Arthur Condominium Association to represent the custodian in all matters. And pursuant to the February 11th order, they are paying Williams, Bax, and Saltzman $370 an hour for partners and $230 an hour for associates.
March 3rd. March 14th.
March 14th, 2019.
Okay.
That
You
was-
called me on that specific date.
Right.
That's the first time you called me, March
Right.
14th.
Yeah.
During that call, you told me that you talked to the custodian. Isn't that correct?
I don't remember that call, but I do remember looking, when I first found out about the case, I looked up the court docket, and I saw that there was a motion up that morning.
No, but when you called me, you said, before you filed the written appearance on March 20th. On March 14th, 6 days before your written appearance, you called me, and during that, first you left a voice message, then I called you back and we talked. And then during that call, you told me that you talked to the custodian. Do you recall that?
I don't recall telling you that I talked to the custodian.
But did it happen or not? Did you talk to the custodian before you called me?
I don't recall if I talked to the custodian on March 14th, 2019, before I talked to you.
Okay, so it happened, but he doesn't recall. That's what I'm telling you. It doesn't matter what you're saying. So, those attorney fees that he's asking for, some of them are with him coordinating with you because he said you report to the custodian, right? And when you talk to the custodian, you're talking to his attorney, which these fees, he's charging the $60,000.
I don't know. I didn't go through. The $76,000.
When you coordinate with the custodian, who do you coordinate with?
You know, Alan, if you want to ask questions, you need to either wait for an answer.
Yeah, sure. I'm pretty excited.
I mean, you are excitable.
He's right. No, I'm not excitable. Right now I'm excited.
Yeah.
I can be excited right now.
Right.
I did bring in a petition.
Because it's the first time, like when he called me on March 14th, I gave him specific instructions. And he was supposed to meet later next week, but then he went ahead by himself on March 20th and filed a written appearance. And he started litigating the case all by himself. Without it. You and me, we were board members all the time, from that time until now. He never contacted the association, never contacted the board. Did he contact you?
Never.
Okay.
Well, actually, I was asked by Ms. Banco's attorneys not to contact her.
Isn't that a conflict of interest and they should recuse themselves or she should recuse herself? If that's
No, that's
or
not.
you should recuse it. Somebody should recuse it.
They're not a conflict of interest if the attorney that represents Ms. Banco asks them not to contact her individually.
So the attorneys asked you not to contact her. That's a very good discovery.
That is a good discovery.
Who did that? Kilgallen or Especk?
I don't recall. I spoke to both of them.
So they told you that she cannot do her duties as a board member. That's why not to contact her. or-
Petition for approval of custodian's fees. Yeah, in their petition, the custodian is asking for $10,000 in custodian fees. $50,000 in PRM fees and $14,000 in legal fees.
Okay, and those were paid to his attorney, Mitch Bryan, is that correct?
I don't know, it doesn't have them itemized, it just says status RFP, invoice dates, it doesn't include the, well, it says receive Exhibit G, I don't have Exhibit G with me, maybe those invoices have specific.
So throughout the last year, how often were you coordinating with Mitch Bryan?
That's a Coordinate is the wrong word for it, but
Use whatever word you find suitable.
after a court hearing, I would inform my contact, the custodian, what happened at the court hearing.
Do you sit with him? Did you have a meeting with Mitch Bryan?
Have I ever had a meeting with Mitch Bryan in person?
Or on the phone or online? Or by email?
I have had phone conversations.
By so you can say
I have had phone conversations with Mr. Bryan.
So you had phone meetings with Mr. Mitch Bryan. How many hours do you recall?
No, I don't recall.
Are they a lot or far apart?
Not frequently.
So part of what the custodian is asking for is actually charged because they were talking to you. Because you met Mitch Bryan and he's going to charge his hours, right?
I assume so.
Okay. Did the association authorize, or the court authorize this?
Did the court authorize whether or not Mitch Bryan can charge for his time?
No, not that.
I
Authorized.
believe he did. He entered a court order on back in March of 2019 saying that the attorneys for the custodian would be able to bill at their rates.
Yes, for the custodian tasks, which do not include managing the litigation.
With the way the litigation has gone, the custodian kept having to appear in court over and over. They're certainly going to charge a lot more for having to go to court for a 3-hour hearing than they're going to charge.
Who made them appear? Who asked them to appear?
Well, the custodian had to appear every so many months to submit their reports. They're going to be represented by counsel. They often would send 2 attorneys to different hearings. I don't know if they were charging.
Those reports are specified in this order with a 1-hour maximum to charge for. There's a specific section for those reports. And that 1 hour is, I think, maybe $100 an hour or something.
Yeah.
So, and he doesn't even have to appear. There's a cap on how much they have to charge for those. But the custodian appeared for many other things, like the cameras, things that probably you requested of him, or maybe Kilgallen, I don't know, maybe you can elaborate on that. The things he appeared for are not part of his responsibilities. Calling for a board meeting, not part of it, or elections, not part of his responsibilities. Cameras, all other things he appeared for, other than his reports, which also include things that are not part of his tasks, but everything he appeared for, they were not part of his tasks as ordered by the court. As an association attorney, did you try to protect the association from this kind of financial liability when you're discussing with him? Did you tell him not to do that? Did you tell him to stop at any point?
Well, I can't talk to you about my communications with them.
It's the part where it's confidential, if you're saying that.
Yeah.
Well, you are the plaintiff in the case.
No, but I'm asking about the association's interests now.
Right, and my attorney-client communications are protected.
He's not your client. The association is supposedly your client.
You're right, but they are protected by my ethical obligations. And during the time, there was a court order from March until last month that I was to report to the custodian, which is what I did. And since you are the plaintiff, I can't very well discuss with you my communications with the custodian.
No problem. Well, you can and you should, but I'm not going to dwell on that now. I just have one final question, maybe then Shelley has a few questions. Tell us about State Auto and the relationship between them and LewisBrisbois. What's the full name of your law firm?
LewisBrisbois Bisgaard and Smith.
LewisBrisbois Bisgaard and Smith, LLP, that's the name of the law firm. So, are they the clients of LewisBrisbois? Again, let me rephrase my question. Are state auto insurance companies clients of LewisBrisbois Bisgaard and Smith, LLP?
From my understanding, yes, we do represent them.
From how long?
I am not aware. I've been retained by State Auto in about 10 cases over the years. And
so you also appear, not only the
No, I have never appeared for State Auto in a case as their client. They've never been my client.
No,
they've been our firm client because I'm aware that we do different work in different areas, but I've never worked for State Auto as my client.
Okay, so your answer is they are the clients of the firm, LewisBrisbois, but you didn't personally work with them.
I have never worked on a coverage case for State Auto.
Do you know how long back your firm's relationship extends with State Auto?
No.
You read the motion to disqualify that the plaintiff filed. in court, and it has some examples of those cases from back 2018, where LewisBrisbois has been representing state auto insurance companies in many different jurisdictions, Texas, West Virginia, Georgia, different states. And those are only samples. There are many others. What do you think about that?
What do you mean?
What do you think about the fact that LewisBrisbois represents state auto from all that time back, while you represent the association?
It's not unusual for an insurance company to be represented by a law firm. It's not unusual for an insurance company that retains a law firm to represent them to also hire that law firm to represent the insured clients.
But this law firm, this insurance company also filed a lawsuit against the association. The insurance company is plaintiff, the association is defendant. That lawsuit was filed in August 2018, before you appeared, and I'm pretty sure you already know about that lawsuit when you came to defend the association.
Actually,
and this makes them adversaries. Is it usual for a law firm to represent two adversaries?
No, that's, you misstate the question, but it's a poor question. But no, it's not unusual for an insurance company that hires, it's not unusual for an insurance company. An insurance company has a duty to defend its insureds, and when the association submits the lawsuits to the insurance company has a duty to hire attorneys. They hire attorneys to represent the insured in the lawsuit to defend the lawsuit, and if they go about and do something else on their own, they can do that. We could never, as a law firm, represent state auto in a case against Bell and Arthur Condominium Association, such as what they did, and as you probably know, it's not our firm that was involved in that coverage action, and I actually was not even aware of the coverage action until the lawsuit was going on, or until after we'd entered this case.
What date were you become aware?
I don't know what date I became aware, but I became aware because we'd go to court, and I think at least Harmony had mentioned in court that there was a coverage case. So I knew that there was coverage cases going on. That's not unusual.
At what point did you know there was a coverage case?
Some point in 2019.
When you knew there was a coverage case, I'm going to come to what you just said, but do you agree with me that state auto is the adversary of the association when they file a lawsuit in federal court against the association?
They were the plaintiff in a case against the association seeking a determination of the coverage under their lawsuit.
So they become adversaries because one is plaintiff, one is defendant. Like you say, you can't talk to me because of conflict of interest, and because I'm the plaintiff, the association is defendant, or it's the same comparison. When somebody files a lawsuit against somebody, instead of coming to them and talking to them, trying to solve whatever disputes they have, then they're adversaries, right?
You're torturing the logic, but they are.
Yes or no?
No, you misstate things.
So when state auto filed a lawsuit,
it's like you take a large amount of information, you distill it into the way you want, and you misunderstand it. I mean, the situation is so
clear to you.
Your question is very clear to me.
Okay, you can think it's clear, but the association is in a very tenuous position right now because state auto no longer hires us. We're only hired by Andover, and what's going to happen in this case is Andover also has their own, I believe they have their own coverage action going on. I don't know the status of that. I talked to Mr. Chemers a few weeks ago, and he had indicated that...
yes, but all these extra information are good, but you didn't answer my question.
This is the reason why I came here, because I think time is of the essence.
I agree.
And right now, there's a couple different ways that this case is going to end. And it's either going to end with a settlement, it's going to end with a motion for summary judgment where the rest of the complaint is dismissed, or it's going to end with a trial. And as long as Andover is still involved in the case, if it ends in a trial and the plaintiffs win in the case, then the plaintiffs will get some money from Andover. If Andover wins their summary judgment and you no longer have an association attorney.
But Andover is not a party.
Andover
is not a party to win something.
Andover, I believe, is part of Cambridge. So
Cambridge is not a party in this case. Are you talking about federal case now?
No. Yes. You don't
represent us in federal case.
I don't represent you in the federal case.
Okay.
But what my concern is, what happened once State Auto won their case is they sent me a letter saying that we're no longer retaining you. I contacted Andover and they said, okay, we're going to start paying all of your bills. What's going to happen in this case is if Andover wins their summary judgment, then the association is no longer going to have a defense.
You're talking about federal case again now, right?
Yeah.
I just want to make sure you're clear. You're talking about Northern District of Illinois.
When
did we start talking about
Andover wins their coverage action?
When did we move to that subject?
Yeah, when did we move?
I have to leave because I have a deposition at 10:30. So
Okay, I'm done with my question. Do you have a question for me?
He basically got to my last question, which was the very important one, but it's not getting answered. So
Okay.
I just want to move on to the next.
Okay, but just before
I want to express my concern about the time of being of the essence, because what's going to happen is if you no longer have an attorney, that's just going to delay the case more. We tried to settle the case in February.
What if the plaintiff... Sorry, go ahead.
We tried to settle the case in February. We thought we had a written agreement in place. And then when we came back to another hearing, Alan had new terms and new demands. And then he told us in March that he was going... The court ordered him in March to give 10 days to give us a written settlement demand. I'm still waiting for that written settlement demand. And I hope that we can resolve the case. That's the stance that I've taken over the last 7 months. I barely touched the file because I thought we were going to settle. If we don't resolve this case quickly, I fear that Andover is going to win their coverage action, and then the association won't be represented by counsel. Then, if Alan wins his case against the association, there's not going to be an insurance company that will have to pay the lawsuit. The first thing Alan did after the association wasn't represented before was to move to default the association.
Yes, I did file a motion for default.
If the association is defaulted, then it just loses. So the only person who benefits from this case is Alan. The association is the association is in a dire position, and it needs this lawsuit to be over.
About my first settlement demand, when you received it, did you share it with anybody?
Yes, I forwarded it to the custodian, who is...
But not to the board, right?
Correct. I had a court order telling me that my point of contact was the custodian.
Yeah, but he's not managing the defense of the association.
You can argue semantics, but that was what the court order was.
It includes specifically that he doesn't manage the defense, the court order. April 24th.
He doesn't manage the defense. He's my point of contact, and that's who I was reporting to for that year. And I not only shared that with him, he was also president of the settlement conference.
Yeah, but who asked him? Nobody asked him to be president.
I didn't know why. Well, the court asked Mr. Henley to be president of the settlement conference. And when the court made recommendations as to the settlement, the custodian agreed to all the demands that the court recommended.
No, there was no agreement. That was drafted by you, and then the custodian...
I've done this quite a few times. Normally, the verbal agreement, we would have been done that day, but we were told to leave and confirm that everybody agreed to the terms that were recommended by the judge. We left. The custodian told me that, yes, the association will comply with all these terms, and you came back and had new terms.
My concern is that when I gave you a demand, you didn't share it with the board. Like everything else you did, you didn't share it with the board at any point throughout the year and a half that you had appeared. And you're going to say now that the court had ordered you to do that, but you moved the court in the beginning.
Correct.
And the association did not tell you to move the court, to tell you to coordinate with who. There was a board. Minto was under a restraining order, but there were 2 board members. The association did not ask you to appear on March 20th, 2019. Isn't that the truth? The board of the association. Did you receive an official board decision from the association? Or did you go to the board?
I went to the court and I brought the motion because the board was not communicating. And I couldn't very well...
How do you know that? Who told you that?
Because I talked with you and I talked with Mr. Kagawa and I talked with Mr. Douglas. The board was not communicating. And I couldn't very well go to the plaintiff.
So you revealed client information to the attorneys of S. So Errol This is Ron Payne.
That's Ron Payne.
I wish you were here earlier.
Yeah.
I just got home, I went to work at 5 o'clock, so I can be here for...
So you're saying in March 14th or March 20th when you filed your appearance, you're saying that the attorneys killed them?
That chair.
It falls down. Yeah, it's not good. You're saying that me and Shelley were not talking, and that's the reason you went and talked to the kill them?
That's not what I'm saying. I'm saying that there was nobody to report to for the board.
How do you know that? Did you try to? When you called me, up until now, actually, the court order is still in effect. The only authorized representative of the association. Now, still with that, with people being board members, I'm not going to do anything on my own, but when you called me, the effect of that order was still there, and I told you I'm the only authorized representative as per the court order on June 11th, July 11th, or July something, 2018. And your only client-attorney relationship should be with me. But even if not, even if you wanted to meet with the board, you didn't ask me for that, did you?
Oh, no, I couldn't ask you for that because you're the plaintiff.
But the board, not me. Did you ask me to meet with Shelley? Did you ask Shelley? You sent an email to Shelley
You
recently,
told me
didn't
that
you?
you were the only valid member of the board.
No, I told you there's a...
You told me that you were the only
Did
valid
I tell
member
you not
of the
to
board.
contact Shelley?
And you also told me that you would decide whether or not to authorize me to defend the association. That's the reason why
I have meeting minutes of that meeting with you, and it's with the
Yeah, your meeting minutes are not accurate.
You're going to dispute them. That's I expect you to do that, of course. But again, you sent an email to Shelley recently while you haven't contacted her before. Did you try to send her an email back then?
I did not have her email address back then, and no, I didn't contact her back then.
You talked to her attorneys. The thing is, you are asking her attorneys for a decision regarding the association, and that's what you're telling me is that you revealed confidential information for the association.
No, I didn't reveal confidential information to her attorneys.
You asked her attorneys to give you a decision regarding her position as a board member.
No,
and you
I
didn't
did not ask them for a decision regarding the board member.
Principal-agent relationship, there's no one in between. You have to talk to the principal, and then you are an agent. Same thing applies for an attorney-client relationship. You know that. You graduated, you've become a bar member since 2006. You should know that better. Or I think you do. That's not that you don't know it. But when you appeared on March 20th, 2019, that was not by instruction of anybody allowed to give instruction for that, because the custodian did not have any order to tell you to do that. The board, actually the custodian up until now doesn't have that order. The board, you never communicated with the board at any point. Let's say you had good faith to communicate, but you couldn't, right? And then when the restraining order against Minto was lifted in September, did you try to communicate with the board after that? Since you're saying Shelley and Minto are non-conflicted?
Did I try to communicate with the board following the termination of custodian? Yes, it's one of the first things I did.
When did you do that?
I sent a letter to you and Shelley.
So now it's okay for you to communicate with me at the board. Like 5 minutes ago you said you were not
Correct.
communicating.
And I made it very clear that I sent a communication that didn't include any...
Which letter are you talking about now?
I sent a letter to you telling you...
What date is that?
I sent a letter to you telling you that I do not represent you. I sent a letter to the 3 board members.
Oh, that recently? You mean you're talking about the one in September?
With non-confidential information in it.
Oh yeah, they forwarded that.
And then I sent a confidential letter. No, they didn't forward that to you. I sent it to you as well.
No, you didn't send it to me as well. But look,
I sent
you sent me a letter. You sent me a letter.
I sent a letter with non-confidential information in it.
Okay. Okay, maybe then that's the one I'm
To
talking
you.
about. So you sent them something that you didn't send to me.
Yes, of course.
Who allowed you to do that? Was there a board decision to allow you to do that?
I don't have to have a board decision to send a letter to the non-confidential.
What date was that? Was it in September or in August?
It was in September.
This month.
Yes.
September 2020.
Yes.
What is the time there was a motion filed against you to disqualify you as an attorney for Villa Welfare Association? What's the time that motion was filed?
I believe you filed the motion in August.
Correct, yes. So you outreached to the board only after there was on the record evidence that you represent the adversary of the association and other evidence that you have no client-attorney relationship with the association.
Your-
That's the only point.
Your question's invalid, but I did reach out to the board the week of the termination of the custodian. As soon as the custodian was terminated, I prepared a letter.
But it was after the motion to disqualify.
Yeah, just because
The custodian was-
something is chronological does not mean it can also be.
When was the date that the custodian's term would end on his?
The court ordered it on a Friday, but then the order wasn't actually entered.
No, I'm not talking. I'm talking on the original February 2019 order for the custodian. There was a specific date that says July 31st.
There was a date in there, but the court didn't actually order the termination until August 24th.
No, but it says it's terminated unless the court ordered otherwise.
It did.
Did you after July 31st, or maybe at the week of that date? Let's apply the same standard. Did you try to outreach to the board saying, well, look, the custodian's term is ending, or is going to end, or ended, and we need to do this and that? Did you do
No,
that?
Mr. Calgowan had filed a motion to terminate the custodian as of that date. We appear in court.
I'm not talking about.
Hey, you want your question answered? I'm answering the question.
I don't want the gown. I'm talking about you.
Yes, Kilgallen had filed a motion to terminate the custodian. You had joined the motion. We were in court, and actually, I believe you had asked the court in open court to go ahead and terminate it immediately as of that date, and Judge Taylor said no. And he continued that, so even though the court order said they were going to...
The judge didn't say no, the judge said, I cannot enter that order this date.
Correct. So even though the original order back from February, before I was ever involved in the case, said that the custodian was going to be terminated on July 31st, when that motion to terminate them was actually brought up, the judge continued that to a later date. And when the judge finally ruled on the custodian being terminated, that's when I contacted the board directly.
Which also after the motion to disqualify you.
Correct.
Okay. Do you have any questions?
It's all cool.
Well, from now on, we have this paper regarding communication. It specifies the mailing address, the email address. It was adopted through a board meeting. Could you receive it from me? I'll give you a copy to sign receipt. Just a second. Could you write here your name and the date it was received? You can verify with Shelley that it was adopted through a board meeting today. I just want you to write that it was received. And your name, please. The date. So how many papers do you have?
You gave me the court order of August 24th, 2020, 2 pages, and you gave me to whom it may concern official contact information of the Delaware Condominium Association.
Okay. This is taken care of. We have this letter for you too. It's 6 pages with the service list. I also want you to sign that you received it. And also, if you could write the number of pages, that would be great. Also, we have one last paper for you. Well, it's not for you, but you are copied in this, so we're also giving your copy in person, and I want you to sign the receipt. Great. Does anybody else want anything from this gentleman? No? All right. We're out of here.
Okay.
All right, thanks.